Mr. Jensen.
Good morning, Your Honors.
Thank you.
Richard Jensen for Liberty Mutual Insurance Company. As this Court is obviously aware, this is the second time this case has come before it with respect to the interpretation of Section 31 of the Workers' Compensation Act. The first time this case was here, the decision that was issued had a footnote, specifically footnote 6, which referenced the possibility that a minimum benefit would be due the claimant, excuse me, even if there was no wage replacement available to her under Section 31. The case was remanded to the reviewing board, where the reviewing board had decided that indeed the $110 minimum under Section 31 was available to the claimant. We have taken an appeal of that. We disagree with that, and we are now here based on that appeal on that specific issue. I'd first like to say that I think that the problem with the reviewing board's decision is that it fails to just look at the plain language of the statute. The statute here states in paragraph 1 of Section 31 that a dependent who is wholly dependent upon the employee's earnings for support is entitled to benefits. The reviewing board should have never gotten past the initial paragraph to get to then the next section.
Could I ask you, though, I understand your argument that we should focus on that paragraph by itself is the literal doorway, if you will, to any benefits. But it says wholly dependent upon his or her earnings for support at the time of his or her injury or at the time of his or her death. And I understand that Mrs. McDonough was married to the decedent certainly at the time of his injury. And at the time of his injury, he did have earnings, and she was dependent on those earnings. Why doesn't that literal reading of the first paragraph of Section 31 do it for her?
Well, I would refer this Court back to its original decision in this case, where looking at that particular paragraph, that it's at the time of the death that applies in this case because of the latent injury.
In other words, you want us to say that we meant what we said in the first McDonough's case.
Yes, Your Honor.
That's the essence of your argument.
The first McDonough was about then how you get into the calculation. You know, what time is the calculation done? But I'm not sure that the first paragraph of Section 31 has anything to do with the calculation. Indeed, your argument says that it doesn't, that you don't even move on to the next paragraph. That has nothing to do with the next paragraph. And she was, seems to me, dependent on his earnings for support at the time of his injury.
I think that the statute would be considering the fact that in those cases where the 35C applies and this Court's decision that one must look at the particular language of the time of the death. But I do also make the alternative argument that under the second paragraph that also it's an antecedent about a minimum payment should there be a calculation of a wage replacement. If I could turn to that, I think that it's very interesting to look at prior to 1982, the statutes of 1982 had amended the statute and rewrote the statute. At that time, the award was a flat 110, which prior to 1982 was the number for all compensation, regardless of the actual employee's income. And it seems to me that what they've done when they amended the statute, they kept that 110 in as a minimum because, as everyone knows, inflation, wages typically are higher than that, but they kept that in as a minimum, not as a flat benefit, because under the 1982 statute, prior to 1982, I should say, that was what was permitted as a wage replacement for earnings. And so it appears to me when I read the second paragraph, there is one sentence that talks about you get either 2/3 of the average weekly wage, which we know in this case is nothing, and then it proceeds to then say, except for a maximum or a minimum. And those are the two next phrases in that sentence. And under traditional statutory interpretation, it's an antecedent which it defines, which is that it goes back to the idea of wage replacement, which sort of raises the question about this case being about a wage replacement provision. There are certain provisions within the Workers' Compensation Act which are wage replacement, and those are closely tied to the idea of replacing an earning or an earning capacity. In this case, it was zero. So to say that it's some sort of benefit unattached to earnings just doesn't go along with the rest of the statute either. And I would say that the reviewing board has gone into a very complicated analysis, which is very difficult to understand, and I don't fully understand how they reached it. But it seems to me that they are trying to talk about a wage replacement plus. But wherever this statute has provided benefits that are not related to wages, they've done it in a separate distinct.
In fairness to the reviewing board, with all candor, I mean, the reviewing board starts off with footnote 6 and says, I think the reviewing board took that as a statement of our interpretation of the issue which is now in front of us, correct?
Yes, I think they do, and they. But sometimes I think their argument gets circular. I think that they just.
No, I understand
yeah.
that, but it's a little difficult if you've got a Supreme Judicial Court opinion that says we assume, and then. I mean, that was my reading of the reviewing board's decision. And
I cited in my brief the fact that I consider it dicta, where this has not been fully considered by the court. In fact, I think the footnote states that it's not actually making a decision on the matter merely by the fact that it points out that this issue had not been fully briefed or raised below. But I do think it perhaps did influence the reviewing board to say, well, you've got this footnote here.
Well, they start off their decision saying this is the law. Correct?
Well, the footnote says quite clearly, we assume that whether this benefit is available to the claimant will be considered.
No, I understand that, but
I mean, there's no conclusion there that it is at all.
Yes.
And the footnote is really just suggesting that it's an open question, something to be considered.
Yes.
Not a command.
Not a command, no, Your Honor. And I think that perhaps they took it a bit more than just highlighting a point to be raised on remand, that they felt that it was available because there's language saying apparently there's a minimum benefit. But I just don't see how the reviewing board can avoid the clear statutory language, a plain reading of the statute, and go into a rather convoluted analysis of different provisions, referring to other provisions to support the history of the other wage replacement provisions and pointing out distinctions among them. It's a very confusing and I think unnecessary analysis that the reviewing board goes through, because you don't even get to that if you just look at the words of the statute. And you've got that one sentence in the second paragraph, which even if we get past the first paragraph, is clearly there are two antecedent phrases talking about when you get compensation and what are the maximum and the minimum. That's what it's looking at. And I think if you look at the statute prior to 1982, you'll see that that 110 comes from the fact that prior to 1982, $110 was the benefit. That was it. And so it would appear that they're keeping that in as a minimum as time has gone on, as wages have increased, and where they've enhanced the benefit up to two-thirds of the earning capacity for a death benefit. They are nonetheless keeping that old 110 as a floor, like a minimum benefit.
Mr. Jensen, forgive me for interrupting you. I take it that you, and I haven't had a chance to go back and look at Mr. Locke's treatise on this matter, but I take it that you disagree with the reviewing board's interpretation of the Locke treatise on this point.
Well, I think the Locke treatise was hypothesizing, yes. I mean, to the extent that there is support for their position, I think it's incorrect because I just look at the plain reading of the language. And the only reason you go to a history and into these interpretations which go beyond the statutory language is if you are trying to avoid that language. And I think that they are clearly avoiding the language of the statute. And this Court has a de novo review based on the interpretation of plain, ordinary meaning of statutory language. And I would ask this Court to look at this case, first and foremost, divining the legislative intent from the language of the statute without going to some convoluted kind of analysis, which I think they undertake.
I don't wish to be unfair to you, but may I conclude that if we go to look at the statutory history, the analysis that the reviewing board gave of that history is not inaccurate?
I would say it's misguided, absolutely misguided. I think that it is an analysis which doesn't really look at the history of 31. It tries to it's very hard for me to figure out exactly where that analysis is going, but they look at other wage replacement statutes and talk about the fact that there are different benefits available under them. It seems to me that they're leading towards the idea that, well, since there are different treatments based on permanent, total, temporary, the percentages of a wage that you are entitled to, a 2/3 versus a 60, depending on which provision you're falling under. They're trying to say, I think it leads up to their wage replacement plus language that they use. And they're trying to say that, well, we do all sorts of things in these wage replacement provisions.
Well, except their position is, which is somewhat in line with Justice Sussman's reasoning, which is that when you amend the statute to add, or at the time of death, that language, everyone recognized that was replacing, that you just have it fixed at the time of the injury, and that, in the board's view, the reasonable interpretation is to say, if you can't do that, provided that you are covered as of the time of injury, you get a minimum. You may be able to get more, but you get a minimum. But you pick up on Justice Sussman's point, is that you look at the coverage at the time of injury. If she was wholly dependent on him at the time of the injury, that's the threshold door through which you go.
And I respond to say that even if you get past that first paragraph,
then you've got to go to
I still
paragraph
think
2.
that even under that, there's even more, a stronger statutory interpretation to state that it's an antecedent describing what wage replacement you get, provided, however, it won't be over a maximum, under a minimum.
Okay.
And, going back to the whole purpose of the statute, we have here a statute which is about wage replacement. In other situations, as harsh as it was, and I believe that was one of the words this Court used in its decision, as harsh as the result may be, it is not about making this into a tort statute where you get benefits outside of the wage replacement unless the legislature has specifically stated it. For example, attorney's fees or health care reimbursements for medical care and burial expenses, where they've made a specific non-wage related benefit. They've set it out in a separate section, clearly stating, here it is. But this is wage replacement, just like 34A, 34, and 35. All of them are wage replacement based on a weekly benefit. A weekly benefit is so closely tied to the idea of replacing wages.
And
but
you say his wage at the time of death was zero.
Yes. And this Court has said that, too. And when I read the decision, until I saw that footnote, I thought the case was over. And I hadn't thought about the idea that that would ever have been interpreted as meaning that it's a separate benefit, like a life insurance policy on a weekly basis, like an annuity, under the statute which is about wage replacement. And this Court, as many, many times before, including in this case, talked about the fact that this is about replacing wages and not about giving other kinds of benefits. And that's part of the trade-off of the whole system, where we don't allow tort claims. And in a way, by saying all of a sudden the reviewing board that, well, this is a bad case, it's death.
We replace tort claims with another
Yes.
method of compensation.
Right, but foregoing your rights to go to court and obtain personal injury damages, including pain and suffering, they've gotten this no-fault system in place. And perhaps in a death case, it's maybe the most awkward way to look at this, this harsh result, as I think this Court had said. But nonetheless, that is the purpose of the statute, is wage replacement. And it really has been limited to the wage replacement unless a separate, distinct statutory section has provided for something different.
If he had not taken his pension as a lump sum, would your argument be any different?
I think the facts, had they been different, I don't know what I suppose it would be a factual finding of the judge, number one, perhaps, of the hearing judge, but clearly in this case there was a voluntary lump sum acceptance, and I believe even Mrs. McDonough had voluntarily signed off on that lump sum. Had it been a different case where he had retired, I think there is room to say that there are earning capacity cases that go beyond retirement. But this case, the facts did not support that. There was never any issue raised as to whether he had ever left open the possibility of re-entering the workforce. And I think in those cases, I suppose wage replacement is, one could argue, and this is going back a bit more to, I think, your prior decision, is that earning capacity, it's not just what he was earning, but maybe an earning capacity. But I think in this case, there was no earning capacity because he voluntarily left the workforce permanently. And I think the lump sum payments were part of that evidence. The lump sum payment of the pension was to demonstrate that he was no longer obtaining any work.
Thank you, Mr. Jensen.
Thank you, Your Honor.
Mr. Leuenberg?
May it please the Court, I'm Franklin Leuenberg. I represent the claimant appellee. You asked a question in your footnote, and you asked the reviewing board, apparently regardless of the actual wages earned on the date of eligibility or of the formula set forth in Section 35, whether this benefit is available to the claimant will be considered on remand on this minimum benefit.
Other than that footnote, Mr. Leuenberg, if we adopted your position, why wouldn't that be inconsistent with our prior decision in this case, other than the footnote?
Well, I'm sorry, I don't understand.
If we adopt your position, would your position be inconsistent with the prior decision, the earlier McDonough's case, except for that footnote?
No. No. In your decision, as Judge Sossman pointed out, what you said was there was no average weekly wage to take two-thirds of. And then you quite correctly looked at the statute and saw that there was a minimum benefit that, as the department, the reviewing board said, after considering the language, defines an unconditional fixed entitlement unrelated to the amount of wages. And that's absolutely correct. Can I point out to you, Your Honor, that if you look at Larson's, which I cite in my brief, which is a very learned treatise, when we workers' comp lawyers in Massachusetts reach a blind alley when we don't have an answer, which is why we're here twice on this case, which is rather amazing to me. Quite an honor on my part to be in front of you. But we go to Larson's, and Larson's is very instructive. I cited it in my brief, and if you look at page 1-2 at the very beginning of Larson's, it says, in death cases, benefits for dependents are provided. Arbitrary maximum and minimum limits are ordinarily imposed. Dependents, in exchange for these modest but assured benefits, and that's tort benefits, it's workers' comp benefits, give up their common law rights to sue the employer for damages for any injury covered by the Act.
But is he referring to death that occurs in the course of employment?
Yes, Your Honor.
We don't really have that here, in a sense, do we?
Well,
We
the injury...
do, Your Honor. We do. Through great efforts, proved that this employee died as a result of his injury at work. He had asbestos come into his lungs. When he retired, he was dying. It was as if he had been mortally wounded, and it just, because of the latency period, it took a little while for him to die. But he died because of an injury at work. There's no question about that. And when you look at Larson's, Your Honor, I refer you to Appendix B, Table 12, which is at page App B65. In that table, it tells all of us, that there are 41 states in the United States that have these minimum benefits. There's 3 that have also minimum benefits, but they're not statutorily prescribed. I don't know what that means. There's one unknown, And there's only 5 states in the whole United States that would deny minimum benefits.
Mr. Lernberg, let
Yes,
me
Your Honor.
ask you this. It seems to me that what complicates this, and I mean, it is a complication, is 2 things. One, in response to Justice Spina, I fully understand that that you proved, and I accept, that he died as a result of an injury suffered at work, but the nature of the death was over a longer period of
Yes, Your
time. So that's a little different from somebody who falls from a scaffolding or dies very soon after an injury. But what complicates it here is that he took a lump sum benefit payment, and that, it seems to me, adds the slight wrinkle here, because in a sense, if you take the lump sum benefit payment, I don't know on what basis that was calculated, but I assume actuarially based on for however long there was an estimate that he would be, quote, injured. So,
can I address that question?
well, can I just ask you?
Absolutely.
Sure. And then, would I be correct in assuming that it's your position that he was paid in the lump sum benefit for his injury, his incapacity to return to work, and not for his death?
Well, I'm glad you asked this question, because I want to clear this up.
Okay.
See, I'm not aware of how familiar you are with compensation, workers' comp, and how
If
much you're not.
Mr. Locke hasn't told me about it, I'm not very. And Mr. Larson is right behind Mr. Locke, but I
Well,
like the local boy myself.
Well, you've written so many learned decisions that have taught me a lot about workers' comp, and I thank you for that. On lump sum,
Yeah.
let's talk about lump sum.
Okay.
Lump sums are governed by Section 48, I believe it is,
Yeah.
and this case was never lump summed. Never. And let's be really clear on that. The lump sum that you see in the documentation from my brother is talking about a retirement situation. There is nothing in the Workers' Comp Act, Chapter 152, that talks about retirement, except I think it's 135E, which says that if you've retired, if you're a retirement age, then you can't come in and ask for current benefits, and that does not include Section 31, incidentally. There has been no lump sum of this case.
Well, what's the $178,000 then?
The $178,000, Your Honor, is something about a retirement system that was a contract between Mr. McDonough,
Which is what, didn't his wife sign a document?
She may have, Your Honor, but she never, to lump sum a workers' compensation case, and that's what we're talking about here, you have to come in to the department, you have to appear before a judge, and you have to present, as an employee, or dependent, you have to present your lump sum to that judge, and that judge has to approve it. That has not been done here. The idea...
I think what you're saying, I hope this is correct, is that this lump sum has to do with his pension rights, nothing to do with his injury or workers' comp or anything.
Absolutely, Your Honor. And I feel terrible coming here today that wasn't made clear the last time around. And I apologize to the Court if that's the case. But absolutely, there has been no lump sum. And to talk about a lump sum, whether he took a one amount for his retirement or whether he got it weekly or monthly, I mean, this is all actuarial. This has nothing to do with workers' comp. Right. We're talking about...
I take it, correct me again if I'm wrong, when you say it's got nothing to do, you may mean that, and you may be correct that as a matter of law, but I take it, I don't know this, but I would assume that one way that you trigger access to retirement benefits may be because you have been injured. Is that correct?
That's another good question, Your Honor. As a workers' comp lawyer, I've been practicing workers' comp since 1970. When you get to a situation where you have a catastrophic injury and you're concluding that an employee can no longer work, or a death case...
Or chooses not to work.
I'm sorry?
Or chooses not to work.
Or chooses not to work.
Sure.
But generally what we're talking about is a situation where an employee cannot work.
Okay.
That's why we, as workers' comp lawyers, come in. If an employee chooses not to work, that's something else.
I'm talking, could arguably, but has been seriously injured, and the company says,
Right.
yes, this entitles
So
you to.
generally what we do is, first of all, we're concentrating on the workers' comp benefits.
Right.
And we're either having the department order the benefit to be paid either weekly, because that's all they can do. They can't, except in a very few cases, they can't demand a lump sum. Or what we're doing is we're negotiating the benefits with the workers' comp insurer and reaching a lump sum under Section 48, a lump sum that gets presented to the Department of Industrial Accidents. But then, in addition to that, we would look and see, well, what other benefits are available, not workers' compensation benefits. This lump sum that Justice Cowan referred to is totally different, totally outside of workers' comp. It's a different consideration. And yes, if you are a proper advocate, yeah, you'd look at that also and seeing how that ties in. But it is a separate matter. And again, I'd point out that with 35E, I believe it is, that talks about not paying benefits because of retirement. 31 is not included in that statute. You will not find anything in Chapter 152 that talks about retirement. It's not there.
Are you telling me that at the time that he negotiated his retirement benefits, he did not negotiate any workers' comp benefits?
He didn't know he was
Correct.
injured then. He did not know he was injured at that
That's correct,
time.
Your Honor. You're absolutely correct. Nothing was done about workers' comp. It was after he died that they came to me, that I looked at what happened to this gentleman, that I collected the information, that I presented the information to the Department of Industrial Accidents. We went through their whole system, all the way to the reviewing board successfully, and then got here and reached a technicality about this average weekly wage situation. But at no time has there been a settlement of this case.
When did he retire? Forgive me.
He retired, Your Honor.
91, my
91.
colleague tells me.
91.
Okay.
Yeah. And what you're really talking about here, with all due respect to all of you, Your Honors, if a client came to me who had a latent disease and asked me for advice, what I would advise that client is don't retire. Stay working. Keep an income stream going so that when you die, because you're going to die, you'll have an average weekly wage for your widow to get a Section 31 two-thirds benefit paid on. But in this
Counsel, what was his wage at the time of death?
You mean at the time
of death?
last
None.
work, Your Honor? The wage that was determined by the judge who heard the case at the department was $1,077.88. He was a highly paid worker.
But I thought that Justice Allen's question was what his wage was at the time of death.
Well, that was zero.
At the time of death, yes.
Zero.
He was retired.
And in McDonough's case, we struck down, in essence, the regulation which said that if it's zero, you go back to the average wage on the date that he last worked. And we said that went beyond the statute for purposes of calculating the benefit.
Yes, Your Honor. Can I just point something out? When you look at what happened at Amaranth just a week or so ago, they lost 50% of the assets of this hedge fund. Now, what happens to a Mr. McDonough who does not have any of the expertise of these luminaries in this hedge fund, that he loses the money that he lump summed in his retirement? And now he says, gee, maybe I have to get a job. What do you say? I mean, he's dead. He can't do that. And I think that that's something that wasn't considered below. And I'm just throwing that out to you. To say to Mrs. McDonough's estate, well, you know, you don't get anything. Although the statute says what it says, you don't get a payment here. I just think it is incredibly harsh. I think it's contrary to the statute. And it just doesn't work within the system. Walker's case. You decided Walker's case recently.
Yep.
And in that case, you talk about beneficent design, humanitarian measure, adequate protection for workers' independence, presumably, that it's a remedial statute, that it deserves broad interpretation. You noted that exclusivity eliminates the employee's common law remedies against the employer. And in doing that, you reflected the statutory intent of the legislature when you did that. You also decided very recently in last November, McCarthy's case, where you again said that you give substantial deference to the reviewing board. And you again noted some of these things that I just stated to you from Walker's case. So I think that it's clear that benefits should be paid in this case. Can I point out something else, Your Honors? The concept of wage replacement plus was mentioned by Mr. Jensen this morning. Let me just tick out a few of the statutory provisions that tell you that this statute's about more than just wage replacement. Section 24, exclusivity. You referred to that in the case I just mentioned of yours. Section 28, double compensation. Doubling the compensation, how is that wage replacement? It goes way beyond, it goes doubling beyond wage replacement.
Well, I think the Court is generally aware that essentially what you have is a balancing. Somebody gives up all of their tort remedies in return for which they get a certain package of remedies, which may include wage replacement, but may in certain other circumstances include other kinds of benefits.
Yes, Your Honor. Yes, Your Honor. And to say in a situation of a widow that because of a technicality and an average weekly wage, you get nothing, certainly flies in the face of the spirit of this Act, the intent of this Act, and the way the Act is applied. In terms of deference, I'm sorry.
With that wonderful flashing red light, all I have to do is point without interrupting you in the middle of a sentence, Mr. Lewis. Thank you very much, Mr.
Thank you, Your
Jensen.
Honor.